Jail.
It's the same. I don't usually come here. If you look at my record, no felonies, no misdemeanors. But currently, I'm being harassed by a group of
No
white.
felonies.
Oh, of course not. No, I'm being harassed by a group of white and Spanish terrorists that seem to work for the police department. Every month, I seem to have an incident with a misdemeanor charge. And
If you violate these conditions, if you pick up a new case, I will put you in jail. You will not get any more PR bonds. The only thing I'm asking you to do is don't have any contact with this person. That's it, and no weapons.
I understand.
Welcome back, everyone, and buckle up, because this hearing spirals quickly into one of the most emotionally layered courtroom sessions we've covered. What starts as a routine probable cause hearing turns into a collision of mental health concerns, custody disputes, and escalating violence that puts multiple families in crisis, all under the watch of Judge David Fleischer, who has to balance compassion with one overriding priority: public safety. In this opening exchange, you're already seeing warning signs. The defendant insists he has no criminal history, but claims repeated harassment and persecution, and we're hearing early indicators of mental health struggles. These early statements matter because judges listen for credibility, emotional state, and whether someone understands what's happening around them. Here's the twist. This courtroom session is not just about one person. Over the next several minutes, we'll watch cases involving custody disputes, alleged assaults inside hospitals, mental health breakdowns, probation violations, and bond revocations. Each moment shows how quickly legal problems snowball when stress, family conflict, and untreated mental illness collide. And here's what makes this gripping. Judge Fleischer repeatedly tries to slow things down and prevent situations from getting worse. But some defendants keep landing back in front of him again and again.
Hi, Lisa Strauss, Majestic. So this happened in Montgomery County, weirdly, in a hospital in Montgomery County. So you might want to look into that.
You, Monica Villarreal?
Yes, sir.
Ma'am, you stand charged with the offense of assault of a family member. This is a Class A misdemeanor. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and any abuse of the state of Texas. If you cannot afford a lawyer will be appointed to represent you. Please don't say anything.
On April 24, 2024, officers followed up on an investigation into an assault that occurred on April 18, 2024. Officers spoke with a complaining witness who stated that at 2001 Brook in Kingwood, Texas, the defendant, his ex-wife, was upset that he was already in the admittance process at the hospital after she arrived. The defendant slapped the defendant in the mouth with her hand, causing pain. The complaining witness ID'd the defendant via a photograph. The officers obtained a video footage.
Now things get serious. This is no longer just courtroom confusion or emotional tension. We're dealing with an alleged assault between divorced parents, and it happened while their child was being admitted to a mental health facility. That detail changes everything. Legally, assault of a family member in Texas is a Class A misdemeanor, but emotionally, cases like this are often far more complicated. These parents are already navigating custody battles, medical decisions, and emotional exhaustion. One wrong move in a high-stress moment, and suddenly you're facing jail time. Notice how the judge immediately starts clarifying jurisdiction. That's not courtroom trivia. Jurisdiction determines where a case can legally proceed. Filing in the wrong county can delay or even derail prosecution. Judges have to get that right before anything else moves forward. But here's the bigger picture. When divorced parents are arguing over a child's medical treatment, tensions explode fast. Hospital environments are already emotionally charged, and disagreements over care decisions often lead to confrontations. And let me ask you something. If your child was in crisis and you felt the other parent wasn't acting in the child's best interest, how would you react? Would you stay calm, or would emotions take over?
Of the incident that corroborated the story.
So he's in a hospital being admitted?
No, their child was being admitted to a mental health facility, and they're divorced and they were having a dispute over the child. And so, and actually this happened in Kingwood, Judge, which is in Montgomery County.
Is that true? Let's see. Where did this happen?
So this be the bottom of summary of the facts. The incident occurred in Harris County, Texas. I, Officer Amber Wright, declared the penalty of perjury that the foregoing is true and correct based on the information and belief. That's part of the death.
Do you want me to look up the address to
Sure.
see? I mean,
It's our understanding it's Montgomery County, but I don't know how it was filed here, but it just,
Lisa, so Damien, where did it happen? What's
2001 Ladbroke,
2001 LAD?
BROOK.
Is it Kingwood, Texas? I mean, it's an Humble. It's like right out of like 2 minutes out of Humble, right? Atascocita.
yes.
That's Harris County. No?
It is, but when it's considered a hospital, the jurisdiction is not, that's not with the.
No. What matters if it's it's in Harris County. I don't care about laws and this and that.
Okay.
My only concern is it really in Harris County?
County or Montgomery County.
Was it in Montgomery?
Montgomery County, it's Kingwood Pines Hospital, mental hospital. Kingwood Pines Mental Hospital.
I don't know. I think
April
it's
8th.
Harris County.
But no, not the date, doesn't matter.
Okay,
Just, it's okay. I'll look into it.
Look
Judge.
into it.
Yes, I'll look into it.
And if
It's
it's
okay.
truly if it's in Montgomery County, then it should have been filed in.
It's okay. Just leave it alone for.
Let me tell you something.
We'd rather it be here than Montgomery. leave it
Be
alone.
careful what you wish for.
Yes. 'Cause it's
Really?
easier to handle here than Montgomery.
Really?
Just leave it.
Okay.
I do know that.
Okay.
Go ask around.
Yes,
I
we'd
promise
rather
you.
No,
be
I
here.
know.
I just,
I've heard.
yes.
Yeah, right.
I just,
Okay.
yes.
Mhm.
When I heard Kingwood, I was like, that is Montgomery County, so that's why I was,
I don't know. Maybe
I'll look
some
in-
parts
I'll
are
look
in.
yeah, I'll look into
Some-
it, but just don't say anything. It's okay.
I don't know, but Harris County handles a lot of things differently.
Yes.
Criminal cases versus Montgomery County, I'll tell you that.
I've heard.
So for right now, I'm gonna find that there's probable cause.
This moment is procedural, but incredibly important. When the judge finds probable cause, it simply means there's enough evidence for the case to move forward, not that anyone has been proven guilty. Viewers often misunderstand this step. Probable cause hearings are about confirming whether charges are legally supported, not determining innocence. That happens later, in trial or through plea negotiations. But listen closely to how the judge handles the situation. He's less focused on punishing past behavior and more focused on preventing future conflict. Why? Because domestic disputes are among the most likely cases to repeat. The judge's tone shifts from technical to protective. He's already thinking about conditions that will keep these parents apart and prevent another confrontation. And here's a tough question for you. When parents are fighting over what's best for their child, should criminal courts step in aggressively, or should family courts handle it instead? Because right now, this case sits at the intersection of both worlds.
So
Approximately like not even a mile away from Montgomery County.
Okay.
It's still in Harris County.
okay. So my question now is, do you have a RIP done?
No, I do not have a record yet on the charge.
So is this
They're divorced.
okay?
They've been divorced for 2 years. They share custody of the children.
Okay.
And this was an issue involving, the
Guys, keep it
hospital-
down, please.
The hospital is the hospitalization of the child, not of the defendant. I mean, not of the complaining
Right.
officer.
How old is the child?
12.
Not to be 12 August 1st.
Yes, almost 12.
Okay. Do you have primary custody of the child?
I have primary residence and just for school.
Yes, who has primary custody?
Typically, in these,
For primary conservators. I'm the domicile. I'm primary domicile. I wanted primary mental because this is the second time that she's been in the
Attempted
hospital.
suicide, Yes.
Yes. And
no, my concern usually because of these high stress situations, I usually order no contact with the complaining witness in this type of case because you know, being that it's even more high.
This is where Judge Fleischer draws a clear legal line. No matter how justified someone feels emotionally, taking matters into your own hands can land you behind bars. He repeatedly directs her to family court because custody disputes, medication decisions, and parental authority issues belong there, not in criminal court. Criminal court steps in only after things have already gone wrong. Notice how emotional this exchange becomes. The mother fears her child isn't getting proper care, while the court warns her that continued conflict could cost her custody entirely if she ends up jailed. And here's the painful reality. Judges see this pattern constantly. Parents fighting so hard for their children that they accidentally make their situation worse. Let me ask you, if you truly believed your child was in danger, would you break court orders to protect them? Or would you trust a slow legal process? Because in moments of panic, legal consequences rarely feel real until you're standing in court facing charges.
High stress, that's only going to add to the frustration, and I don't want anything worse to happen.
She was already in custody. She didn't witness any of this. Got it. And
No, he's not saying no contact with your child. He means no contact with your ex.
Oh,
That's
yes,
no
my-
contact with the ex.
Amy said to speak with you about that. We have a go-between, that we have had, or she's like, she's the babysitter, like a nanny,
That
but
exchanges that you exchange the children through.
yes, ma'am. And she's been with them both since they were 6 weeks old. She saved my son's life when he was choking. And she is actually, she's like their grandparent. They're, I don't want to say anymore.
Okay, that's fine.
Is the child currently still hospitalized? She's out?
She's out, but,
Still having issues. Yes.
well, I don't know what else I can.
No, that's all. It's enough.
I mean, we don't need to know.
Comply with the medication. I've had to go and get the medication on his possession. Sneak it
So,
into her because it's a psych medication for her not to kill herself.
so the complaining witness you're saying is not administering the medication to the child as
Correct.
needed.
But, and he cussed her out and it's in a text from her. And
So-
he said, I'm not paying.
Yeah.
Thing is that, ma'am, in these types of situations, what you need to do is you need to go to the felony. You need to go to the family court.
I haven't.
Yes, and that's,
Already have.
yes, she's working with a family law attorney. Yes.
You need to go to the judge and say, look, judge, this is what she needs. If he's not in compliance, then you take,
Yes,
I
she's
have
gone back to the
Petition
family.
away.
I have it. I have it all on our
Yes.
family wizard. I had that.
Yes, she's gone back to her family law attorney and they're working this,
you
that's.
cannot take matters into your own hands. Because you're the one that's gonna go to jail.
Now we reach the consequence phase. A PR bond, or personal recognizance bond, allows someone to leave jail without paying money, based purely on their promise to follow conditions and appear in court. This is the judge saying, I'm giving you trust, but only once. And notice how direct he becomes. If she violates conditions or picks up new charges, jail becomes automatic. Judges often escalate consequences gradually, but this is the final warning. Protective orders and no contact orders exist to cool down volatile situations. The court is trying to prevent another emotional explosion that could permanently damage this family. And here's something viewers often miss. Violating a protective order is itself a criminal offense. So one text message, one angry phone call, or one confrontation at a custody exchange can trigger another arrest. Do you think strict no contact rules help families calm down? Or do they sometimes make co-parenting impossible? Because next, the courtroom tone shifts again, and things get darker.
I'm ordering you now not to have any contact with him. Do you understand?
Yes, sir.
I don't care how stressful it is. When I mean no contact in any way, no text messages, Snapchat, phone calls. The gentleman that was just here now, same thing, Snapchat messages. Where is he now? He's in custody. I don't want to have to do that.
But I do want to.
Can they communicate about the
record.
exchange of the children through family law, the wizard?
No.
I mean,
Okay.
no contact means no contact at all.
Okay, today he gets back possession. How do I?
I would use
Linda?
your nanny as the intermediary.
That's fine.
Yes.
She's the one that can have contact with him. What's the nanny's name?
Linda.
Linda,
You contact Linda, tell Linda what to say. but I
She knows.
don't want you to have contact with him at all.
I just want
That's
it on the
That's-
record.
on the record way.
If my daughter dies, it's on his hands.
There's nothing, we can't get that on the
Go
record.
to the family court and ask for an emergency motion and an emergency hearing immediately. You
Okay.
can do that.
Okay,
They have ways to get to a judge if
I'll go
there's an
today.
emergency,
I'll leave today. Here,
really. But
there to my retainer.
don't take matters into your own hands. It's really going to go sideways. And imagine what's going to happen if you go to jail. What's going to happen to the 12-year-old?
And they have a younger child too, as well. Yes. Okay, we just have to handle it through the proper channels. He just wants to make sure you're handling it through the proper channels.
It's okay. You'll get through this. We just need to find the proper avenue to get through it so that everybody gets attention. And I'm telling you, if he's not doing the way that he should, the family courts should help you out. Lisa knows how to handle these things. If you ever have any issues, talk with her. All right.
And I'm in
Now-
communication with her family law attorney as well. That Ned Gill, that's who referred her to me, so we're in communication, so we will
Feel
get
your
this figured out.
pain. And I just don't want to add to any more of the stress, but I think that if you just kind of break away from this individual,
Yes,
I
then
understand
hopefully
your-
good things will happen. All right, I'm gonna set your bond at $100. I will give you a PR bond today. I'm gonna tell you now, Ms. Villarreal, I will not give you another one.
This case moves quickly, but it shows how routine plea deals function in busy courtrooms. Criminal mischief cases often resolve through agreements that trade short jail time or time served for avoiding trial. Trials are expensive, time-consuming, and risky for both sides. Many defendants choose certainty over gambling on a verdict. Notice how fast this proceeding moves compared to emotional custody disputes. When evidence is straightforward, cases can resolve in minutes. But quick resolutions don't mean minor consequences. A conviction stays on record, affecting employment, housing, and future sentencing. So here's a question. Would you risk trial hoping for dismissal or accept a guaranteed smaller penalty to move on with your life? Because the next case reminds us how quickly unresolved issues can spiral.
If you violate these conditions, if you pick up a new case, I will put you in jail. You will not get any more PR bonds. The only thing I'm asking you to do is don't have any contact with this person. That's it, and no weapons.
I understand that.
You ever have any issues, talk to Lisa. I know her well. She can come to me and we can hash these things out.
I already took away Reese's phone because she kept asking questions.
Okay.
I couldn't answer.
Yeah, any issues, just talk with Lisa. She can, Damon, anything else?
No, Judge.
Do you mind filing the order for no contact, no weapons, please?
Judge.
One more thing, I am going to issue a protective order, okay? This is a protective order that identifies Ruben Villarreal as a protected individual. You cannot commit family violence or an assault, no threatening, harassing communication. You cannot use another person to communicate a threat or harassing behavior. You cannot go within 200 feet of where he lives or where he works. This order is good for 61 days from today. If you have any issues, like I said, Lisa can get a hold of me. We can iron these things out.
exchanging kids through a third party, through Linda.
That's fine.
Okay,
Right.
We were doing that anyhow.
okay, good. Okay,
Any questions? Okay, if you do, like I said, she'll get a hold of me and then we can hash these things out. Do not leave because we need to have you sign a bunch of paperwork. Now, one more thing. Because you have a representing you, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with Ms. Strauss.
she will.
She'll tell you if and when you have to come back to court. Don't go AWOL, otherwise I'll issue a warrant on it. Okay? I believe that. Okay, thank you, Ms.
Okay,
Thanks.
thank you.
That one was just sad. I hope she gets a good lawyer and goes to family court and the kids are taken care of. Having a kid in mental health situations is always bad. Going through a divorce is always bad, and you mix the two and it makes for some bad situations. All right, here's a few more.
Good morning, ma'am.
This is Cephas, Your Honor, for a plea.
I'm Ms. Cephas.
How are you doing today, sir?
Ma'am, you're charged with criminal mischief. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement where they're offering you. Cephas, please.
4 days with 14 days credit.
4 days in jail with, I think you said 14 or 4. 14? 14 days credit. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront, cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this agreement, you can never change this. Is this what you want to do, ma'am?
Yes,
How do you plead to the offense?
guilty.
I will find you guilty.
This is where public safety takes center stage. The defendant allegedly assaults both a hospital employee and, days earlier, his own mother. That's a rapid escalation. Assault inside medical facilities is taken extremely seriously because staff must safely handle vulnerable patients. Violence there threatens everyone present. And now mental health enters the equation. Defense counsel raises schizophrenia, institutionalization, and suicide attempts. Judges face a difficult balance: treatment versus incarceration. But repeated violence forces the court to prioritize safety. Compassion doesn't erase danger. Let me ask you, when someone's aggression may stem from untreated mental illness, should courts focus on punishment or mandatory treatment? Because Judge Fleischer now faces one of the toughest decisions any judge must make.
Standing you to it. Good luck to you, man.
God bless you.
You too.
Just want to see this.
Take care, man.
Thank you. God bless you.
Good morning, Mr. Moses. I brought you out here because I want you to, since these are your cases, it's only fair that you hear what's going on, okay? So,
Order in the court.
Mr. Moses, I want you to understand
It's the judge. You don't need to be looking around, sir.
there's nothing over there for you. So my number one concern is public safety. And if you are going to endanger her, I'm going to do everything in my power to take you off the street. You were on bond for an assault and you were let out. You were in the free world. I see that now you've picked up another assault. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. I don't know anything about it. And I don't remember even what happened on your first assault. So we're going to find out, and we will now see if you were a danger to the public. So can you please read the new one?
The new one first.
The new one first, please. Yeah.
So on May 16, 2024, officers were dispatched to a disturbance with an unknown weapon at 2108 Gessner Road in Harris County, Texas. The complainant witness is a mental health tech and is an employee at the Houston Behavioral Healthcare Hospital. The complainant was moving the defendant to another unit in the facility that was more secure, that has more security and staff due to his behavior. Defendant struck the complainant in the left side of his face with a closed fist. The complainant felt pain from the assault. On the way to the other unit, the defendant struck him again with a closed fist on the left side of his face, causing pain.
Okay. So what happened with the first assault?
And on 3 days prior, May 13, 2024, officers were dispatched to the disturbance at a family, for family violence at 8323 Cinnamon Lane.
This is the turning point for Mr. Moses. Up until now, the court was still trying to understand whether these incidents were isolated or part of a pattern. But once multiple assaults stack up while someone is already out on bond, the judge's hands start to get tied. Bond is essentially a trust agreement between the court and the defendant. The court says, "We trust you to remain law-abiding while your case is pending." But when a new violent charge appears during that period, especially assault, judges almost always revoke bond. And notice something critical. The judge isn't celebrating this decision. He's frustrated because he can't get answers. Mr. Moses won't engage, and without cooperation, the judge cannot determine whether treatment, supervision, or release conditions would keep the public safe. This is the brutal intersection of mental illness and criminal law. Jail becomes the temporary solution not because it helps, but because it prevents immediate harm, while competency and treatment questions are addressed. And here's something to consider. If someone repeatedly becomes violent due to untreated mental illness, should they remain in jail, or should mandatory treatment facilities replace incarceration? Because right now, the system often defaults to jail simply because there's nowhere else to safely send them.
Unit 1001 in Harris County, Texas. The complainant is his mother, who came home from work with food. And while the complainant had showered, the defendant spilled the food on the floor and left it.
He spilled the food on the floor and left it?
Left it on the floor. So the complainant confronted the defendant about the spilled food, and the defendant began to strike the complainant on her face with his fist, causing pain.
Judge, if I may kind of help you out here, you should have before you a request for competency with Mr. Moses here. He has informed me that in my conversation with him that he has attempted suicide on at least one occasion, that he has been institutionalized at the Bentov mental facility, and that he suffered from schizophrenia. He's paranoid schizophrenia, and he's currently taking
The concern is,
Napacetic.
why does it keep happening? Why the constant aggression, Mr. Moses? Why? You have, before this, a month ago, you had a felony assault of a public servant dismissed, a harassment of a public servant dismissed, attempted harassment in a correctional facility that was disposed of, and then an FSRA. Why all the aggression? What happened?
Judge, if with all due respect, I believe that once we have the competent examination, I believe that some of your answers will be resolved here.
I'd like to know what happened.
Yes, sir.
As it stands now, Mr. Moses, I think you're a big danger to the public, man. It's not going to stop. You won't talk to me, so there's no way that I can figure out how we can get this to stop. So I'm going to revoke your bonds.
Now we're watching another emotionally complicated moment unfold. Mr. Briscoe openly describes paranoia, persecution fears, and schizophrenia, while also insisting he's being targeted by authorities. From a legal standpoint, the judge must separate two questions. Is this person mentally ill? And regardless of that answer, are they still responsible for their actions while out on bond? The court doesn't revoke bonds simply because someone has mental illness. But when new felony charges appear while already released, bond revocation becomes almost automatic. And listen to the judge's advice about marijuana and Delta-8 use. Many viewers don't realize substances like THC can intensify paranoia and psychosis in people with schizophrenia. What feels like stress relief can actually worsen symptoms dramatically. The defendant feels persecuted. The judge sees repeated criminal charges. Both realities collide in this courtroom. Let me ask you, if someone genuinely believes they're being targeted, how should the legal system respond while still protecting the public? Because perception and reality don't always line up, but consequences still do.
I'm sorry, Mr. Moses, but on the new assault, it said at 5,000. I guess that he had gotten a PR bond on that one.
I believe that's correct.
Yeah, I'm taking the PR bond away. We have to find out why these aggressive issues keep happening, man. And at that time, once you learn to cope with this, hopefully we can let you back out. Okay.
Thank you very much.
Thank you.
We're gonna step all the way up.
Morning, Mr. Briscoe.
Good morning.
How's jail?
It's the same. I don't usually come here. If you look at my record, no felonies, no misdemeanors, but currently I'm being harassed by a group of
No
white.
felonies?
Oh, of course not. No, I'm being harassed by a group of white and Spanish terrorists that seem to work for the police department. Every month I seem to have an incident with a misdemeanor charge, and I am schizophrenic, so they try to use knowledge as if we can follow them. I see them.
Here we see something courts deal with constantly. Defendants trying to explain events from their perspective after decisions have already been made. From his point of view, he was protecting himself and his child in a chaotic situation. But from the court's perspective, the only issue is this. He picked up new charges while already out on bond. Judges don't retry cases during bond hearings. They don't determine guilt or innocence here. And they simply decide whether someone followed release conditions. If new felony accusations appear, bond revocation follows. The judge even softens the moment with humor about urban air, trying to reduce tension, but the outcome doesn't change. The bond still gets revoked. And think about this. Public incidents often escalate quickly when emotions run high, especially when children are involved. One argument in a crowded space can spiral into arrest within minutes. What do you think? Should courts consider someone's explanation more heavily at this stage, or stick strictly to bond rules? Because once bonds are revoked, freedom disappears fast.
Following me all the time. So they use that now to say, who's gonna believe a schizophrenic? So I see them following me all the time, unmarked cars, marked cars. I'm over there right on LA and Greenspoint. I see them all the time.
So one more thing.
What's that?
Don't smoke weed if you got that problem. It's only gonna enhance it, man.
That's the thing. Delta 88 is illegal weed here in Houston.
Right.
That's correct. I do.
Use, because you got these issues, it's gonna make it even more. It's just gonna make it's gonna compound it worse.
When you have a group of different colored terrorists all trying to compete for the best terrorists, sir, and people are using their job to compete with me, and I don't use a job to take advantage of someone, we have an uneven playing field.
Okay. So you're on bond here. What I see that you picked up yet another felony, a retaliation case.
Oh, that's a misdemeanor.
The retaliation.
No. It's a felony.
Oh, I'm taking it to trial, sir.
Okay. So all I wanted to do is bring you out here now. You have an open case with us.
That's correct, sir.
I'm yanking that bond now.
Yes,
You were
sir.
given a PR bond, but now you done picked up 2 felonies. Can't do that.
That's fine, sir. I have a good lawyer and, I'm sorry, go ahead, sir.
No, it's okay. I wanted to let you know what's happening here. It's only fair because it's your case. So,
What would you set the new bond at, Judge?
5,001.
Could we do it, maybe 1,000? He's gonna have to make his bonds in
No.
felony court.
No,
Okay.
I mean, he picked up 2.
I'm being harassed. Are we taking that into consideration?
Well, perhaps here, now you're safe.
How will I be safe around the people that affiliated with harassing me?
I don't know, because we can put you aside.
Sir.
When is he at court?
I have a court date on the 20th, this month on the 20th, sir. My lawyer wants to combine all court dates and we can handle them at the same time if you want to issue that, because I have a good lawyer, sir. He's an ex-NFL player.
That too.
Yes, sir. We can do all of that.
Do you want to put it on the same day, Judge, or?
It's May 28th.
Well, we'll do the day after. Because you have felony court upstairs, we can't have you here both at the same time.
That's
We'll just
fine,
put
sir.
you for the day after. I just want to let you know what's happening with the bond since it's your
Just
case.
to give you a little recap, sir, I was at Urban Air. How violent can I be at Urban Air with my son?
Now we shift gears to something many viewers relate to: driving while intoxicated cases. These hearings move fast because evidence in DWI cases is often straightforward: breath tests, officer observations, and arrest footage. But notice the judge's tone. He uses humor and stern warnings at the same time, essentially telling the defendant that irresponsible decisions behind the wheel endanger everyone. A high blood alcohol reading elevates the charge, increasing potential jail time and fines. And license suspension becomes standard because courts want to prevent repeat behavior. The judge's message is simple: you were lucky this time. Next time could mean mandatory jail time. And it's worth asking, how many people convince themselves they're fine to drive after drinking? Most drunk driving cases involve people who didn't expect to get caught or didn't expect consequences. Let me ask you directly, have you ever had to stop a friend from driving after drinking? Or been tempted to risk it yourself? Because one bad decision behind the wheel can change lives instantly.
Sir, the guy's on me grabbing his gun in front of my son, asked me to leave after I just paid $25 for my son to swing and jump on the jumps. But it all originated from a Spanish lady telling him I was a problem because I was trying to record my son. And then he just started following me the whole time in Urban Air. Waited till he heard something. He put his hand on me. I say, "Sir, you're not the only one with a gun." He arrested me. Hey, gun, and then arrested me. That's how the whole thing started, and that's how it ended, sir. If I committed a crime, I would say I committed the crime.
Be careful, all right? I like Urban Air too. It's a great place, all right? Okay, so just want to let you know what's going on, okay? But take care and be safe.
Yes, sir.
Thank you, Your Honor.
All right, let me get your card to my mom. Wants your card so that I can get your
Sir, hold on, sir.
Oh, sir, where am I gonna get it from? I'm gonna get it to you right now.
Sir, you know I come up here all the time.
I know, Mr. Briscoe, and you know, I'm the one that, Mr. Briscoe, I know you might call him.
Well, getting my hair still really kind of working right. All my food is gone, so I need somebody to go grocery shopping for me.
So the insurance company. Apparently insurance companies are covering that.
That's crazy.
Hola, ¿qué tal? Soy Luis, el de mucho gusto. Ahí cerca. Solo mire, el juez sí le contesta con los fotos. Sí, señor, y no sé. Ok, yes, sir. ¿Qué preguntas en la?
All right. Good morning, Mr. Lopez.
Good morning, sir.
Sir, you're charged with driving while intoxicated. First offense. It's elevated to a Class A misdemeanor because of the high blow. You are facing a year in jail and or a $4,000 fine. You guys have worked out an agreement where they're offering you, Lopez,
3-7.
3 days in jail with credit for the 7 days that you've done. You're giving up the right to a trial, and this applies to you as well, sir. Both of you guys are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not citizens, your possible immigration consequence, you can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you accept this agreement, you can never come back and change this, challenge this. It's over today, it's over forever. Now, Mr. Lopez, this is a DWI. What you're doing today will not happen again. From now on, you are facing a minimum of 90 days in jail. If you were not smart enough to consider how to get home on a night of drinking, I will put you over my knee and I will spank you with 90 days in jail, just like a little child. Now, I'm going to suspend your license to drive for a year. Do not drive until you get a license. And this is Mr. Wyrick.
3-9.
Mr. Wyrick, you were charged with resisting arrest. You've been given an offer of 3 days in jail with credit for the 9 days that you've done. This is also a Class A misdemeanor. You're facing a year in jail. This will go on your record. It will be there forever. If you pick up any more cases, you will be also facing a minimum of 90 days in jail. You understand?
Yes, sir.
How do you plead to the offense, sir?
I think guilty.
Okay, sir. How do you plead to the offense? Guilty or not guilty?
Guilty.
I will find both of you guilty. I will follow the agreement, roll your court costs so you won't owe anything, and good luck to you.
Thank you.
Thank you.
Thank you.
There were 2 cases in there with mentally ill people. Both are disturbing because both show how dangerous they can be in society. If they're faking, I wouldn't know. I'm not trained to detect that, nor do I care. If they're truly sick, we need to find a way to help them while protecting society. Hope you guys enjoyed the video. Looking forward to making more for you.
What we witnessed today was more than routine court proceedings. It was a snapshot of how complicated real-life justice can be. Judge David Fleischer handled custody conflicts, mental health crises, repeated assaults, probation violations, and impaired driving, all in a single session. The common thread? Stress, untreated mental health issues, family conflict, and poor decision-making often collide before people ever reach a courtroom. And once they do, our judges must balance compassion with public safety. Some defendants received second chances through PR bonds and plea deals. Others lost their freedom because repeated incidents showed growing risk. In mental health cases especially, courts struggle between incarceration and treatment. And society still hasn't fully solved that problem. The final takeaway is this: the courtroom is often the last stop after many earlier warning signs. Legal consequences usually follow personal crises that were already building. And that brings us to you. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Because every case tells a story, and we'll be here breaking down the next one with you.